You realize that the CDL is now going to be suspended. You realize that a second DWI conviction, you'll lose that CDL for life. Do you realize that? Yeah, a second DWI conviction, you'll lose the CDL for a life. When you are a CDL driver, you are held to a higher standard. The entire world is at a 0.08 legally, right? For what they consider. Come up, Mr. Jones.
Mr. Neiland is in Cancun until Monday next week, Judge, so he's not available this morning.
I
so
understand.
I'm kind of filling in. I have had a chance to look at this violation report regarding missed blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there.
And here we go. Welcome to Judge Fleischer's courtroom, where zero tolerance isn't a guideline. It's a warning etched in stone. The air shifts the moment he speaks. The defendant has a past, and the judge makes it brutally clear. Whatever grace existed before, it's gone. Completely. This isn't a place for excuses. This is a place where every choice has weight, every misstep has a consequence. And the clock on second chances just hit zero. Buckle up, because what's coming next won't be gentle.
Literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
That's 19, Your Honor. That's 7. Within that 7 are included. But Judge, I would ask, if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So
I'm sorry, Ben, I can't. I have to know. You have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, you're on cold weather. I apologize. So can I please speak on the breathalyzer?
No. You know what the expectation is. You have 19 missed tests. That's it. I'm sorry.
This moment is a textbook example of judicial reframing. The defense attorney clings to the one clean detail: no positive UAs, hoping it can anchor the narrative. But Judge Fleischer doesn't give an inch. Instead, he pivots hard, zeroing in on the 19 missed tests like evidence laid out under a spotlight. With that shift, he rewrites the entire story. This isn't about what the defendant didn't do. It's about every requirement they failed to meet. In seconds, he takes command of the exchange, positioning each point like a calculated move on a chessboard. And from that moment on, the direction of the hearing is no longer up for debate.
Ben, I can't. You're here, and instead, you're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please,
No.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate for alcohol.
I go to sleep early, man.
Test. And he is blowing outside the window, so we don't know what he's doing.
Oh my God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock ones first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pre-trial over there, and they said that I had a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor. I will do anything. I'll even go on that drug ankle monitor. I'll do anything, Your Honor. I'm really trying here. I swear to God, I will do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor. It's just I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I do wake up. And they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one
I started
pass after the other. He goes with you. No,
Oh my God.
Your Honor, may we discuss setting a new bond for?
of course.
Oh my gosh. Why? Please, I'm trying to do everything.
Goes with you.
Oh my gosh.
The bond is at 5,001 now because of the prior violations. I'll now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view it. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera,
Yes, sir.
then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 7502, Judge, for bond.
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't, but fine. Because
Visit PC, Your Honor. I have some questions.
oh, you picked up a new case. I'm sorry, I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Yeah, him. Picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case. Specifically, an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, a felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading. And now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay,
Pursuant to the, I guess,
I understand.
that we literally had one after the
Understand.
other, like a rung on a step ladder. One. Yep.
And-
So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may,
I'm not going to I've never withhold anything against him. So let's go.
On December 3rd of 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed what?
located. They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW. And another witness stated she observed the defendant pushed a complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon
But he has an open ag assault somewhere else too?
in Fort Bend County, Judge.
My understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. Like, and they're
I understand that.
they're a 0.1 mile away from the location.
So-
For what?
Well, okay, I get that, but so we have what we have. We've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have,
Okay.
right, Mr. Zenon? There's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
No, it's the aggravated assault, but Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes blank like this for them being unable to effectuate an arrest.
And Judge,
You don't think that's an interference?
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because, I mean, there's no better way. Let's read it.
Hold on.
I'll give you,
Did he really just say goes plank? I love when legal language suddenly turns physical. The defense is trying to spin this as maybe resisting, but not quite interference. But let's be real. When officers are trying to load you into a patrol car and you lock your body stiff like a board, that's not poetic nuance. That's classic obstruction. This moment is a perfect snapshot of courtroom combat. Attorneys dissecting the exact wording of a charge as if the phrase itself could tip the scales. It's not just about what happened. It's about what you can call what happened. And that's where the real fight begins.
all right. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly, they could have
Okay.
taken a whole myriad of, I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on, you know?
but they didn't
Hit.
They took the one that I do not believe applies here.
Let's read the code.
Okay.
Let's see what the code says, because, you know, there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can, it's 3815.
That's okay, don't worry.
You're right. It could have been like a resisting, you know, but. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, So I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so
you.
the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute, that's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
but he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1
It's an
miles
open
away.
felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what or the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like. And that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I
Mhm.
mean, that's what they were investigating.
And the witnesses all described.
They put him,
the
I guess,
defendant.
did they put him under arrest at the time when he said that he was making that threat?
And with being
I mean,
0.11.
did they have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap the misclaim.
And it's at that point they start to put him under arrest?
At that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
But
pushing.
remember,
That's
I
a
mean,
resist.
it-
That's not
it
interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
We don't.
Well, I mean, it's,
Okay, well, I mean, but so
I mean, we don't know. I mean,
Okay, I'm just saying.
if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also
And
don't
yes.
have the offense report
We
yet,
don't
I
Judge.
don't
That's
care.
where
I
he
mean,
was in
but
the
I think that
process.
there's enough, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
I see- I know, but I don't have the video.
I've
I mean, I
shared the
think that-
videos with.
Remember,
You're right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you're disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I gotta say.
Required 3 times to search me.
Can I have a moment to look at the video here? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find,
I mean, because
if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, you know. Okay, it looks like they didn't give him a PR bond on this.
Okay, so well, then we can
The
address it.
bond right now is set at 2,500.
Okay,
Your bond upstairs is set at 5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You know, you got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, you know, and I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, you know, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend Judge and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set tomorrow, Monday, what in?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want, surely. Do you have it?
We have the camera, the body camera.
I just shared.
Okay, so
They just shared it with me.
Yes.
let's roll it to tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Yeah. Okay. All right, Mrs. Zenon. See you tomorrow.
See you tomorrow. Yes, give me a second.
She sent me an email from,
If anything, have you done for your GED?
And what I did for it,
What have you done?
I went to a class and then I tried to go yesterday. They canceled it and he also,
You went the day before court.
and I also went before.
Judge, she's been going. She's been going before even the last court date, and we, you know,
Prove it.
I can text him.
In this life, you are only as good as the proof that you don't have. If you don't have proof, you have nothing. Spoken word means absolutely nothing.
Judge, the instructor, I got an email from him that she sent me saying that she's been going to the classes and that class was canceled on the 4th yesterday. But she did, you know, attempt to go to the class. So she's been going. She did already take a test, and this is one where she did fail the first test. So she's been working on it. It's not enough.
I mean, here we are. How many resets have we had? We've had 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 resets since May. You're now in December. You have had 5 to 6 months. Show me the money. Otherwise, it's not going to go well for you today, Ms. Dixon. Show me. 5 to 6 months.
And Judge, this was a case where she was paying for the classes, and then she had to then enroll into the free program, which she's been doing for the last little bit.
Are you playing Candy Crush? What's going on over there?
Now I'm trying to text him.
Texting who?
The instructor, like what I'm supposed to show you. Cause I don't have no proof, like I don't have nothing.
Tell me what have you done?
I went to the class.
Okay. Which class did you go
The
to?
GED resource.
Okay, and what, because the way I understand it, there are different modules that you do. You do science, you do language arts, you do math, you do, and whatever else it may be. You go through each section, you complete it, take a test, and then when you're done with everything, you take an overall test, and then you get a diploma.
That's not.
What have you
how-
done?
Basically explaining on how everything's gonna go, and I was gonna finish everything else Wednesday when I was gonna go, but the class was canceled.
Who is the provider that you have?
His name is,
Grab me a phone number, because I'd like to call them right now.
I have a number for you, Judge.
Go ahead and put this on.
Oh, yeah. Charles Jackson.
Mr. Jackson? Yes, my name is David Fleischer. I'm a judge here in Harris County. And I have someone that's with me in our court, and she's doing a program with you guys to try to get a GED. I'd like to confirm that's Coriel Dixon. So Wednesday and Thursday, and then did you say every other Saturday? Okay. And then, so how does it work as far as getting the diploma? Do you do different classes as far as science, math, and how do you at the end get it? Can I put you, I have her in front of me. Can I put you on speakerphone so that she can hear this as well? Do you mind? Okay, hold on. So, I've got him. Okay, Mr. Jackson?
Order in the court, please.
Okay, tell me, how goes it?
So, yeah, it's kind of twofold. They take an assessment. Based on that assessment, allows me to know where the student is as far as their grade level in math and in reading. Based on that, they go on 2 tracks. And so one track is like a probation where we're just literally working on kind of some elementary reading and math skills.
Okay.
Or a GED track where they're ready for GED contests. And so, yeah, and I usually just, go from there. I work with my GED students individually. And
how long does the process take? And how long can we expect it?
Well, so that's honestly kind of a loaded question. Depends on where they fall. I believe Coriel scored pretty well.
Great.
So yeah, and I worked with people that have gotten the GED in 3 weeks. I worked with people that got the GED in 2 years.
I can't do 3 years. That's too much.
Well,
I know, I'm kidding.
No, I understand that.
She's been faithfully attending though? Yay or nay?
Yes.
Okay, great.
And with some consistency, 3 to 4 months, maybe less.
That sounds great.
That's just me ballparking.
I'd like to stick with it because I think at the end of the game, our goal here is that she ends with that diploma. And I think that would be a win for everybody. I'm calling you. I want to make sure that everything's going well, that she's attending, faithfully attending and doing well. And it sounds like you're saying that this is what's been happening.
Yes.
Great. Okay, so I'm just going to continue everything. Just continue to go, Miss Dixon. I mean, you got, like what he's saying, if you continue at it 2 to 3 months, you'll end up with your diploma. Okay. All right. Thank you so much, Mr. Jackson. I really appreciate your help. You've been great.
No problem, Judge. You take
Okay.
care.
You too. Thank you, sir. Bye. Great. Good job. Just keep at it. Okay. So let's set it 30 days. I want to ride this through. You're so close to being through. All you got to do is see it to the end, and then everything great will happen for you here as well. Okay. All right. Good job. All right. Good morning, sir.
Thank you for seeing me, Judge.
Of course.
Come before you. I don't really know what I'm doing. I just know that I came before you and I was from out of state. You tried to help me and I was kind of telling you that it was going to be dismissed anyway. I was here 9 days. They shipped me to Arkansas for 30 minutes. It was all done. Set to be dismissed on the 9th. However, the police that stopped me had my car towed and put a card in my property. And so my car was sitting there the whole time. And so I had to find my way back to Houston. Since I've been having Uber back and forth to try to, and I couldn't get my car. It was $540, now it's $1,400. They said, look, you got 4 days, sir, and we're gonna auction off your car. But then they said, if the judge you went before, if he gives you an order, we will release your car, zero balance. Again, Judge.
I can't give you an order to give you your car back. That would be me, in essence, ordering a company that does business to lose money to give you your car back because you don't want to pay to get the car back.
I don't want them to lose money. The thing is, my car was towed erroneously. I was at home. That's why I want to show you the police report. I was at home.
You need to file a complaint with the police, internal affairs. If you're telling me that something was done illegally, immorally, or whatnot, you need to file paperwork with that appropriate agency. But I cannot order a private company to return something to you. I don't have that kind of jurisdiction.
What do they mean you get a judge's order and we release it?
Maybe a civil judge's order. I'm a criminal court judge. The only time I can ever order any kind of property return would be if it's confiscated by the state and they're holding it. So let's say you get arrested, you get pulled over, and you have a gun on you, right? They take your gun and they put it in the HPD property room, right? In that respect, under certain circumstances, I may be able to order them to return it because it's in the care, custody, and control of the state via HPD. Here, your car was towed by a private company and they're holding it, and it sucks. I get it that the bill has ballooned as much as it has. If you ever have a problem, you can always file a complaint with the bail bond, not the bail bond board, but there is a actual board for, there's a towing board too, isn't there?
I'm looking at it, yes.
It's a towing regulation.
There's
a request for a hearing, but I'm reading that it's got to be before the 14th day after the vehicle was removed, is that you have to submit a tow request. The forms are all here. It's 50.
And maybe the fact that you're in custody may toll. I don't know, but I'm not versed on that kind of, and I'm not, number one, number two, I'm not allowed to even give legal advice, but I don't know. But I can't order them to give you your car back. You know, that would literally be me telling them, hey man, you know, just forget about all the money that you've made by holding the car. Just give the man his property back. I can't do that. I don't have the jurisdiction. Maybe a civil court under certain circumstances may order it back, but you'd have to file a lawsuit. You'd have to file some kind of paperwork.
There you go. All right, well, I'm gonna pray for a miracle.
What I would do, perhaps, can you get on a payment plan with them and say, hey, look,
Try that. They zero tolerance. I mean, honestly, I
and I have
think,
to understand, because imagine how many times they've probably gotten yanked,
who knows?
you know?
I wish.
But theoretically, even if I were to give you a court order now, they'd have to, my guess would, they would hire a lawyer, file a motion to quash my order, saying that, hey, he doesn't have the proper jurisdiction to do this, right? And then they may come after you for attorney's fees. My
manager's like, hey, man, if you go to order, I'll release your car to you. He understood what happened. He said, man, just bring me something. I'll release it to you. I'm like, okay, I'm gonna go try.
And a lot of times they say stuff just to get you out, but I can't. I'm sorry. But like I said, perhaps if you talk with the owner, you may be able to negotiate something with them. If you talk with if you talk with someone who has no power to negotiate, you always, if you talk to the right person, if you talk to them at the right time, you may get what you want. So don't go to them at 4:00 in the afternoon because they've been working, they're tired, they've probably dealt with a lot of people, all they want to do is go home. But go there first thing in the morning, try to get to the owner and say, hey, look, here's my circumstance, here's the proof, work with me. I want my car back. And I mean, what do you think? Anything else, Fran?
No, I'll help him out with the tow lot information, and I also have got a copy of HPD's agreement with private tow lots, so that maybe that can help him out.
Thank you, I appreciate it.
Yeah, I'm sorry. But, you never know, it doesn't hurt to try. So just keep trying it.
I'm praying for that.
Yeah, look.
Yes. Thank you.
Okay.
You want them in the middle?
Hey, shh. All right, good morning, Mr. Cordova. Sir, you're charged with driving while intoxicated, second offense. It's a Class A misdemeanor. You're looking at up to a year in jail and or a $4,000 fine. Looks like they're going to reduce it to a first. You need to understand that it's still 2 on your record now. So after today, bless you, you ever get pulled over with the faintest smell of alcohol, dope, whatever it may be, what do you think's going to happen? What's going to happen? Not with me. From now on, you've now graduated to felony court. 2 and 2 make 3. A third DWI, you're looking at a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. And I'm going to tell you that you don't have to be falling down piss-ass drunk where you urinated and puke everywhere. Just the faintest smell of alcohol. They're going to look your record. They're going to assume if it walks like a duck and it talks like a duck, they're going to just rather take you off the street. They're not going to try to be cool and let you go. What happens if you kill a family of 5? That officer's career down the toilet. So in an effort to make sure that doesn't happen, they're just going to take you off the street. And you thought now was bad. Wait till you get to felony court. All you have to do is don't get into a car, even if you've had a sip. One button on a phone, $30 will take you wherever you want to go in this life. No matter where you want to go. How much money have you spent? I want you to know that you are now skirting, by doing this probation here, the mandatory 5 days in jail that you would normally be having to do. But I want you to understand that I'm going to hold you to this probation. Shh. And if you fail to do what you're supposed to do, I'm telling you now, I'm going to lock you up. And if I find that you have a problem with dope, you have a problem with alcohol, I can and will most probably put you in a rehab facility in the jail. Do you understand? No alcohol means no alcohol from any source, no matter how long, whether you're a month away from completing probation, whether you're 1 week. I can't tell you how many times people get back here because they say, oh man, I've got a month left on probation. I've got 2 weeks. They're not going to do anything. Boom, you get tested on the last week of probation. So get ready. You're giving up the right to a trial. right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take this off. You understand? This is what you want to do. How do you plead to the offense of driving while intoxicated? Guilty or not guilty? I will find you guilty and I'm going to sentence you to 180 days in jail. I will probate that for 12 months. As part of the probation for you to successfully complete it, you must do a repeat offender DWI education class. You must do one victim impact panel, a TRAS, which is an evaluation to see what are the conditions you may need. If they assess other conditions, you must fulfill that. It could be intensive outpatient treatment. It could be supportive outpatient treatment. It may be something else. If they assess something further, you must complete it. No drugs, alcohol, random urinalysis, guardian interlock, no breath test refusal. If you were pulled over in a car and an officer asks you to submit to a breath test, you must do it while you're on this probation.
Your Honor, if I may, Mr. Cordova has a scram and he'd like to keep that because he has hired a driver. We know it's a first DWI. DPS, sometimes they may come back and do a hard suspension or 90-day, and we don't want any missteps. So he's okay with that if the court is.
Problem is, I've been paying it for you now. I can't pay for it anymore. You're going to be responsible for this thing on your own now. That thing right there is $500 a month that I've been eating, so you don't have to pay for it. So I don't know how your finances are, but an interlock is typically, what, $100 a month? I don't know, but that, it's at least double, if not more, than what an interlock costs.
Can you afford that?
That's fine. I can't pay for it. I don't, while he's on probation, I can't pay for things.
And that's just my concern. If he gets the breathalyzer, he's not driving, then it's going to be a violation because he's not driving.
We do portable devices.
We tried that, Judge. I don't trust those. I've had a lot of, I think he feels the same. There's been so many issues.
It's up to you. I'm happy, whatever you do, just make sure you maintain compliance. Don't stop charging it. Don't stop paying for it, because at that point, all we're going to end up doing is issuing a warrant for your arrest. $100 donation to the Houston Food Bank and 30 hours of community service. Give children. How many kids you got? I'd rather, instead of the community service, do a parenting class. I think people would be better served with doing a parenting class than just mindless,
I think that's very
dumbass work on the street. Forget about it. No, you're better served learning things in this life than to just do menial work. The idea is that you learn so that you don't come back and that you don't graduate to felony status, because then I'll tell you what, this is going to be hard on you. But when you end up with a felony on your record, it closes so many doors. It's unreal. You lose the right to vote. You want social services from the state. Forget about it. Not when you're a convicted felon. It just closes so many doors. So you need to do everything in your power to prevent that from happening. How do you plead to this? You said guilty. How do you plead? All right. I'll find you guilty. I'll send you to this agreement. One more thing is there are fines and fees that you're going to be required to pay. There's a supervisory fee that you're going to be required to pay for this DWI. It's a $6,000 fee. We will give you time to pay it. I give him 2 years.
We did discuss, he makes a good salary, but he's got 5 children. So I don't know if the court would consider waiving that or.
So what we typically do is we give him 2+ years to pay it, and it ends up being like $100 a month. Just don't stop paying it. What I'll do is I'll waive the court costs.
Fabulous. Thank you.
Okay, so that'll take off like $500, but you'll have to pay the supervisory fee. It's a lot, but we'll give you time to pay it, and don't stop, because if you stop, we will issue a warrant, and your butt's going to sit $100 for every 1 day for every $100 you owe. hopefully this is enough to get your attention, you know? Because at the end of the day, you're walking out of here when you should be doing jail time.
Right.
So it's gonna cost you a pretty penny, but hopefully that's enough to get your attention. You understand?
Sure.
Okay, man. Good luck.
Thank you,
Thanks.
appreciate you.
Oh, yeah, I have to suspend the license.
No, and that's,
I'll do it for a year and then, show me that you're good. I'll entertain an occupational later on if he's doing well and in compliance with the probation.
sounds good. Thank you.
And